You open this door with the key of reason. Beyond it is another dimension, a dimension of truth, a dimension of freedom, a dimension of joy. You're moving into the land of both the ideal and the real, of the possible and the actual. You've just crossed over into the Capitalist Corner.
Where reason meets reality, welcome to the Capitalist Corner.
Welcome to this special edition of the Capitalist Corner. I, of course, am your host, Michael Liebowitz. And as you all know, or most of you know, I've been arguing since the beginning of the war in Iran that it is unconstitutional, that the president does not have the powers that he is using. So today I decided to have somebody on who can make the case a little bit better than I can. He's a professor of law at George Mason University. He's the Kenneth Simon Chair in Constitutional Studies at the Cato Institute. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. Among other things, he's the author of Free to Move, Foot Voting, Migration, and Political Freedom from the Oxford University Press. Professor Ilya Somin, welcome back to the program. Oh, actually, this is your first time on this show. You've been on my other show, but welcome to this show.
Thank you for having me.
So where I want to begin is with the constitutional text itself. Where in the Constitution are the relevant parts that discuss war, and what do they say?
So the most obvious relevant part is in Article 1, which says that Congress has the power to declare war, and you can argue about when a military conflict is large enough that it counts as a war that can only be authorized by Congress. But in the case of the current war, it is very obvious that it is large enough to be a war, and therefore we don't have the kind of boundary line issues that might exist in a closer case.
Well, so Article 2, Section 2 makes the president the commander-in-chief of the armed forces when called in service. What does that mean?
Yeah. So as Alexander Hamilton said in Federalist 69, that means that the president is the highest ranking general and admiral of the armed forces, but it does not mean that he has the power to start wars. It just means that whatever the military is authorized to do legally, the president is the highest ranking officer in the military, and perhaps also the Congress cannot say, well, we designate person X to be a higher ranking officer than the president. But the fact that you're the commander in chief of the armed forces does not mean that you're allowed to order the armed forces to do anything that you want them to do. It just means that whatever it is that they're legally allowed to do, you're the highest decision maker within that realm.
Okay, so on August 17th, 1787, the Constitutional Convention, Elbridge Gerry and James Madison moved to make war to declare war for Congress. Why the change?
So as was explained at the time, and as Madison and others also explained later, that enables him to make war without congressional authorization when the other side has attacked first, right? So particularly in the 18th century, when it could take a while for Congress to meet, it was thought that if the other side launch an attack, then the president has to be able to defend, which would be a power to make war. On the other hand, the power to declare war is a power to initiate a conflict on your own, as opposed to merely react to one that the other side has started. And that was made clear at the Constitutional Convention, and more importantly, in later statements and publications and the like by the founding fathers. This is an issue where Madison and Alexander Hamilton, who disagreed over almost every other major constitutional question of that era, they agreed on this. They both agreed that only Congress has the power to initiate a war, even though the president does have the power to defend when some other country attacks us first.
So I went over some of the Helvetius Pacificus debates, which are Hamilton and Madison. And like you said, it's very clear that they did not want the president to have the power to declare war. I've also been over definitions of war from the time frame, coming from, I can't remember, Vitali, I think his name is.
Vattel.
Vattel, Samuel Johnson's dictionary, Richard Burns' legal dictionary from the time, and all of them have to do with one sovereign attacking another sovereign nation, or having some sort of an armed conflict with another sovereign nation. So does this conflict, you said earlier that it does, but I want you to explain it a little bit. Does the conflict with Iran meet the definition or the meaning of the term war as the people who wrote and ratified the Constitution understood it?
So I think it meets any plausible definition of the word war, both then and today, or really at any time in history. It is clearly two sovereign states, or more than two, but at least two, fighting each other. And the conflict is clearly large enough to be a war, in that hundreds of thousands of troops are involved. There have been thousands of deaths. The fighting has gone on for weeks. And moreover, the objective that the president has enunciated, while he goes back and forth in his statements of exactly what he wants, it seems like at the very least, he wants to do massive damage to the Iranian military potential, and potentially he wants to achieve regime change, which would be great if he actually could achieve it. But it is clearly the kind of thing that involves a war, and not merely some small scale military action or strike that you could argue about whether it qualifies as a war or not. There is a long history of debates about whether small or medium-sized military actions qualify as wars that Congress has to authorize. What is going on here is an easy case. It is very obviously a war.
So among the pushback that I get when I make these arguments, one of them has to do with Jefferson and the Barbary pirates. Now, my take on this is, even if he violated the Constitution, it's still a violation. I don't care if it's Jefferson or anybody else. And the founders certainly weren't above violating it. George, Washington with the National Bank, Jefferson with the Louisiana Purchase. But what exactly happened with the Barbary pirates? And was Jefferson, in fact, in violation of the Constitution?
So I would say this is a somewhat complicated case, and I don't remember all the details offhand, but I'd say a couple things. First, that was an instance where the other side was attacking first. The Barbary pirates had captured lots of U.S. and other ships in the Atlantic. That's why they were known as the Barbary pirates. In some cases, they had enslaved the people that they captured when they took those ships and the like. Second, the scale of the intervention there was much smaller than what you see currently, so that you could try to make an argument that it wasn't enough to be a war. Essentially, the U.S. fought back at sea against the Barbary pirate ships, and then eventually some U.S. troops did land in North Africa to attack them, but it wasn't a massive action. They didn't stay for very long. If I remember correctly, I have to check the record. I think at some point Jefferson actually did get congressional authorization, though it might not have been the case for all the fighting from the very beginning. So I think with that case, you can argue, whether it was big enough to qualify as a war, and whether Jefferson needed authorization given that the Barbary pirates had attacked first. Here you have, and of course, eventually, if I recall correctly, he did get some authorization. I'd need to check the historical record on that. Here you have none of those mitigating factors. This is right from the beginning a conflict where it's obviously large enough to be a war. There's no congressional authorization, and while Iran had sponsored various terrorist attacks against the United States, there was not a direct conflict between Iranian and U.S. forces that the Iranians started. That is not to excuse their horrific record in supporting terrorism and the like, but there is a difference between indirect support of enemies versus direct combat. Otherwise, you would have to say we were at war with the Soviet Union throughout most of the Cold War, because during that period of time, much of the time, either we were funding forces that were fighting their troops or vice versa. But the fact, for instance, that we were giving money to the Afghan rebels, fighting the Soviets does not mean we're at war with them. And similarly, when they were giving supplies and resources to North Korea during the Korean War, or to North Vietnam during the Vietnam War, well, that was a bad thing. It did not mean that we were at war with the Soviet Union.
Wow. Okay. So since 1941, I constantly hear that the United States has not declared war since then, but you argue that it's actually not that clear. Can you elaborate on that a little bit?
So first of all, the last officially stated declaration of war was actually 1942, when we declared war against certain of Germany's allies in World War II. But what we're really getting at is that a congressional authorization for war doesn't necessarily have to use the phrase declaration of war. I think it's enough if Congress passes legislation that people at the time reasonably understand to be an authorization for large-scale military action. And that is, in fact, what we had with the Vietnam War, with both Gulf Wars, and the war on terror in some other instances. So it is simply not true that Congress has never authorized war since 1942. They've done it multiple times. They didn't use the phrase declaration of war, but in context, everybody at the time understood that what was being authorized was large-scale military action amounting to a war, the two Iraq wars, the war on terror, and so on. So it is simply not true that Congress has never done it since 1942. It is true that there have been some previous instances, though arguably not as large as this one, where presidents have gotten away with starting military actions that did legally require congressional authorization, but they didn't get it. But the fact that some previous presidents got away with violating the law, like Obama, with Libya in 2011, which, by the way, I criticized at the time. The fact that somebody previously got away with violating the Constitution is no reason to do it again. There are also every year hundreds or even thousands of people to get away with murder. That doesn't make murder legal, and that doesn't mean we shouldn't catch and punish the next murderer we detect, and the same principle applies here.
So I was actually going to ask you about the Obama situation, but you preempted me. So the case of Venezuela. In Venezuela, they were bombing these boats that they claimed were, in cahoots with the Venezuelan government. Of course, I don't believe that, but that was the claim. They also bombed Venezuela and deposed its leader. I can't see how that doesn't count as an act of war under an originalist interpretation. What do you think about that one?
So I think there's two sets of issues here. One is the strikes against the drug boats. It is questionable whether that is war, but either way, it is illegal. Basically, it's outright murder because these people they were attacking were not actually engaged in armed hostilities against the U.S. At most, they may have been engaged in drug smuggling. The fact that you suspect that someone is engaging in drug smuggling is not a license to kill them without any due process. And in many cases, they didn't even have proof that these people either were smuggling drugs or if they were, that they were on their way to the U.S. with them as opposed to somewhere else. It's not illegal to be in international waters with drugs that might be illegal in the U.S. So while what was done there probably was not a large-scale enough military action to amount to a war, is actually in some ways worse than an illegal war, but for a just cause. Rather, it's just outright murder. It's not even a war crime per se. It's just an ordinary crime. It's the crime of murder. And they did it now 100 times over, killing more than 100 people. With the seizure of Maduro, I think that was an act of war because even though the amount of force that was used was way lower than in the Iran operation, and the attack only lasted a short period of time, seizing the head of state of a foreign government is the kind of thing that generally is considered an act of war. I do think, I don't all feel sorry for Maduro, who deserves severe punishment for his many human rights violations, though not for the thing that he actually is being tried for, which is, trying to smuggle drugs allegedly into the U.S. But that, I think, also was an act of war not properly authorized by Congress. However, it was on nowhere near the same scale as the Iran war. And so the issue there is a little bit more arguable. The administration tries to defend this by saying it was a law enforcement operation. I don't really buy that argument, but it's a closer call than the Iran situation, which is very obviously a full-scale war.
Okay, what is the War Powers Act? And what does it require? Is it even constitutional in your view?
Yeah, so I think it is constitutional, but I think it's a limitation on presidential power, not a grant of power. So some defenders of the military action in Iran, they say, well, the War Powers Act allows it, but that's not true. The War Powers Act doesn't grant the president any new authority. It actually limits his existing authority. So the War Powers Act was enacted in 1973 in the aftermath of the Vietnam War and the real and imagined abuses that happened during that conflict. And it says that when the president sends troops into, quote, armed hostilities or a situation with a high likelihood of armed hostilities abroad, then he must get congressional authorization within 90 days of that. Now, that is not an authorization to send troops into hostilities in situations where previously there was no authorization. Rather, that says is that even if you otherwise are allowed to send those troops into armed hostilities, you still have to pull them out unless you get authorization within 90 days. And there's even a provision of the War Powers Act which says that you can only send troops abroad when there is a declared war or when there is an attack on the United States, or if I remember, the third provision is an imminent threat of an attack or something like that. So it is very clear that there is no new grant of power. There is a limitation on it. A number of presidents and others have argued that the War Powers Act is unconstitutional. They say, well, it limits the president's power to use the military, even in cases where the Constitution does not otherwise forbid it, like even in cases where there's a use of force that falls short of a war, he still has to stop within 90 days. If he doesn't get congressional authorization. I think Congress does have the power to do it because one of Congress's other powers is the power to make rules for the government and regulation of the land and naval forces. And I think rules about where they're allowed to be deployed and what circumstances are part of that government regulation power. But whether the War Powers Act is constitutional or not, it does not grant the president any extra authority to start this Iran war than he had otherwise. To the contrary, if it is constitutional, it's an additional limitation on his authority.
Doesn't it call for the president to have to consult with Congress within 48 hours of the initiation?
I believe so, and I think he likely violated that, though there's questions about exactly who in Congress he has to consult with, but it seems like he did not, in fact, consult quickly enough to meet that requirement.
What? Because I've heard them say, well, you don't have to consult with the entire Congress in that they informed a few members of Congress, and that qualifies. Informing somebody that you're going to do something doesn't meet the standard normal definition of consult. But I just wonder if in this case, does that meet the legal requirement of
So I think consult is one of those sorts of vague terms that clever lawyers can argue about exactly what it means. To my mind, merely sending someone a note saying I'm doing X is not the same thing as consulting, but exactly what level of discussion qualifies as consultation, I think you can argue about that, and I think it's a difficult issue. Another difficult issue is, do you really have to consult with all members of Congress, or is it enough to consult with the so-called Gang of Eight congressional leadership? That's arguable as well. Realistically, courts have said that none of this is likely to be justiciable. So while we can argue about it, it's unlikely that there would be a definitive resolution about the meaning of that. I do think what is clear is that this war is illegal because it is not authorized under the Constitution, and also because, and if it lasts more than 90 days, it will violate the War Powers Act requirement of getting authorization for sending troops into hostilities. But there are these, and I think that's way more important than whether it also violates this ancillary provision about consultation or not.
So I've got a 20-pound super chat here, and it's a question for you, Professor. It says, if in the context of, say, being a person of reason on a jury, would Professor Somin assess the president as of sufficient cognitive ability to comprehend the results of his actions constitutionally or not?
So I'm not a psychiatrist, and even if I was, I think there's well-taken strictures against trying to make diagnoses of a patient you haven't examined. To my totally unprofessional opinion, the problem with Trump is not that he's insane or lacks minimal cognitive ability, although I could be wrong about that. As I said, I'm not an expert on this and I haven't examined him. I think the problem is not that he's unable to understand these basics, but simply that he doesn't care and he's happy to violate the law if he's able to get away with it. By the way, I did check that wording on the War Powers Act, and the third situation where you're authorized to use force is when there is a national emergency created by an attack against the United States or its troops or its possessions. That did not happen at the hands of Iran in this instance, though there could be other situations where there's borderline difficult questions of asking us where has an attack actually occurred or not.
Thank you. And thank you, Phil, for the 20 pounds. Now, people have said to me, well, then Congress should sue. But it's really not that easy, right? Like, in order to file a lawsuit or to make a case in court, you have to have standing.
Yeah.
So what is standing, first of all, and who would actually have standing to challenge this?
Yeah. So standing might be an issue, but the bigger issue is that courts have generally held the questions about war initiation and the use of force or political questions that the judiciary should not resolve. And I am skeptical that this is true or not, but the courts are unlikely to change that anytime soon. Standing is an additional requirement, which says that before you can file a lawsuit, it's not enough that you allege that something illegal has been done by the person you're filing it against, or in this case, the entity or the office holder, but that there has to be some specific concrete harm that you have suffered and that's specific to you and not just a generalizable harm. The exact meaning of this is contested and the boundaries of it are fuzzy, but in general, it has led to a situation where individual members of Congress cannot sue the president for infringing on the powers of Congress as a whole, but the Senate or the House as an institution could potentially sue, and courts did rule years ago when the Democratic-controlled House of Representatives sued against Trump when he tried to build the border wall with funds that had not actually been allocated. A court did rule that the House of Representatives as a whole had standing, even though individual members might not. So in principle, if the Democrats were to retake control of the House or of the Senate, they might be able to get standing to sue as an institution. But the point is kind of moot because they would still probably get thrown out on this political questions issue.
A problem that people like you and I run into is I have no love for the Iranian regime or for Nicolas Maduro. If I could snap my fingers and make them go away, I likely would do it. The problem is we're arguing for what people view as this abstract sort of process or this document and putting it above the needs of the country. Why is it important to uphold the Constitution even when the enemies are clearly evil people?
Yeah. So I would say a couple of things. One is it's very dangerous if one person has the power to take the nation to war. The founding fathers understood this as one of the things they did not like about European monarchs and why they wanted to break with the monarchical system that prevailed in most of Europe at that time. Second, as I pointed out in my articles on this, including in my article in the Dispatch on why Trump's Iran war is unconstitutional, this safeguard not only prevents unwanted or problematic wars, it also increases the chance that we will successfully conduct those wars that we do undertake, because if the president has to get congressional authorization and therefore build up broad public support ahead of time, that increases our sense of commitment, increases our willpower. As Winston Churchill said, war is a contest of wills. If a war starts out with very little public support, which is true of this one, this is actually the first significant military conflict that the U.S. has had in the era of modern public opinion polling, where even at the start, more people disapprove of the war than approve of it, in many polls by large margins. That means we don't have a lot of will or a lot of staying power, and that greatly increases the chance that the Iranians or other adversaries can simply wait us out and just wait till we get tired of it, and therefore increases the chance that we will suffer a defeat. So because the president did not do the work of actually building public support for this war, we now have a situation where very likely people are not going to tolerate higher gas prices for very long. They don't think it's worth it. He hasn't given them much reason to think that it is. And therefore, our enemies notice, and that reduces the chance that we can bring the war to a successful conclusion. So this isn't just some technical legal requirement or abstract principle. It's something that prevents what is often a serious abuse of power. And even when the war is justified and for a good cause, requiring the buildup of public support beforehand increases the likelihood that we can actually win.
We've discussed a lot of the concrete particulars, including the text of the Constitution. What are the constitutional principles that are at stake when a president does what Trump has done?
So I think the basic constitutional principle is that is a decision to go to war is not something that can safely be left up to any one person. We need maybe not a universal consensus, but a broad national consensus for it. And that's what the requirement of congressional authorization leads to. And it both prevents undesirable and problematic wars that are waged in the interest of just one person or a small clique, but it also ensures that when we go to war for a good reason, then there is a greater chance that we can actually prevail because we have more national will to see it through.
When I'm discussing this, the principles that I say are, because people will point out, well, the Constitution's flawed. And of course, I'm not going to disagree with that. But the parts here that are at stake to me are separation of powers, checks and balances, rule of law. None of those are flawed. Would you agree that those are some of the principles that are implicated when a president just goes on his own and does this?
Yeah, absolutely. The constitutional system of separation of powers is not perfect, but this is actually a good aspect of it in that we don't want one person to be able to start wars all on his own for the reasons that I mentioned earlier. And in many ways, this is actually a better rule now, even than it was back in the 18th century, basically, because then you could say, well, it's very difficult for Congress to act quickly because it takes weeks for them to get together. And also, they were out of session during the summer, usually most of the time, because there was no air conditioning in Washington, D.C., and the weather was really bad. So they would go home during the summer. Today, Congress, most of the time, is in continuous session. Even when they're not, they can be called into session in a day or two. We don't have to rely on horses and buggies for them to get back to Washington, D.C. They can, I know this seems radical, but they can get on a plane anywhere in the United States and get back to D.C. pretty quickly if they need to. So if anything, the requirement of congressional authorization is even more useful and more defensible today than it was back in 1787 when the Constitution was drafted.
Before I let you go, I got to ask you about, you recently were part of the Tariff case against Trump. So what was your role in that, and what was the result?
Sure. So this is a whole separate issue. We have to do a whole separate podcast about.
Well, I got you here now, so
but it is relevant, and this is another congressional power that Trump tried to usurp. Essentially, Trump tried to use the International Emergency Economic Powers Act of 1977, which had never previously been used to impose tariffs at all, to impose the highest tariffs since the Great Depression, starting a massive trade war. If these tariffs had been allowed to stay in place, it would have been something like $1.7 trillion in new taxes on Americans over the next 10 years, massive damage to the economy, higher prices, and so on. With the help of the Liberty Justice Center, I filed a lawsuit on behalf of 5 small businesses harmed by the tariffs. To make a long story short, we won in the trial court, we won in the Court of Appeals, and eventually won in the Supreme Court by a 6-3 margin. Our case, in the meantime, was consolidated with one filed by 12 state governments, raising similar issues. And the Supreme Court majority ruled that IEPA, as that statute is known, simply doesn't authorize tariffs at all because the word tariff isn't even mentioned, nor is any synonym like duties or imposts. Some of the justices in the majority also said there are additional reasons why we should win, such as the major questions doctrine, which states that when the executive claims a broad authorization of power from Congress over some major social or economic issue, that at the very least, the executive must show that this authorization was clear on the face of the statute. In here, it just very obviously wasn't. So these IEPA tariffs got struck down. Fortunate for us and for America's businesses and consumers, Trump is now trying to replace them in part with the so-called Section 122 tariffs. I think those are also illegal, and there's new lawsuits challenging them. I'm not involved as an attorney, but I am helping from the outside. If you're interested in this, I have an article in the Dispatch about this, and also one in the Boston Globe. And if you want to avoid paywalls, you can go to the Cato Institute website, where I have a website where they reprint most of my popular media articles, and they have permission to reprint those that are paywalled without a paywall. So you can just go to the Cato website and Google my name and Section 122, and you can see why these Section 122 tariffs are also illegal.
All right, we got a question from the audience. Phil, thanks for the £5. He says, has what many have said was an admittedly flawed but simplistically precise Constitution become seemingly too complicated? What do you think, Professor? Is it too complicated?
I don't know. So I think it depends on what part of the Constitution we're talking about. There are certainly some parts of the Constitution where the words are imprecise and sort of vague. Like think about the necessary and proper clause, which grants Congress the power to enact legislation which is, quote, necessary and proper for carrying into execution other powers granted by the Constitution. What does necessary and proper mean? Well, there's a bunch of different approaches to it. And there's also some other provision in the Constitution where, it's also not always easy to tell exactly what's being meant and how you interpret it. The ones we are talking about today, they're not actually that complicated. While there are some borderline situations where admittedly it's hard to tell whether a military action is large enough to qualify as a war, most conflicts, I think, readily fall on one side of the line or the other. And likewise, it's not complicated to figure out that it's Congress that has the power to authorize war and not the president. And similarly with tariffs, the power to impose duties and imposts, as they're called in the Constitution, is clearly listed in Article 1. There's nothing in Article 2, which lists the president's powers, which says that the president can do this. So there are some things in the Constitution which are vague and imprecise and maybe even badly drafted. It was a long, hot summer in Philadelphia in 1787. They probably got some stuff wrong. And understandably, there's some stuff that they just simply did not foresee that came up later, and some of their expectations that were falsified by events. But with the provisions we're talking about now, they're not actually that difficult to understand, except in certain marginal cases. And I think they make good sense today as well, even though you can certainly argue, there are other parts of the Constitution which, don't make good sense or which are vague and hard to interpret.
I saw on X, I think yesterday, but it was, I think, a repost of a Truth Social post from Trump. And he says that, the tariff case was very important to him, and the judges knew that, and they ruled against it anyway. And it's not the first time he talks like that. How concerned should Americans be with a president that attacks the court in that way?
Yeah. So presidents, like the rest of us, do have the right to criticize the court. When the president attacks them simply for supposedly not being loyal to him or for betraying the country when they obviously didn't, I think those attacks are stupid and reprehensible and not something that the president can do. Sadly, with this president, he's violated so many rhetorical norms and other norms that I would not say that these attacks on the court are anywhere near among the most serious. His bigoted attacks on migrants and promotion of racism and other bigotry, I think, is actually much worse, because at least the Supreme Court justices are powerful people with a lot of powerful defenders. So when he says unfair things about them, it's reprehensible and we should condemn it. But sadly, it's just the tip of this much larger iceberg of norm breaking that has occurred.
All right. Last question, I promise. Is there anything about the constitutionality or the legality of the war in Iran that I didn't ask about that you think is important for people to know?
So I think an important question that doesn't have an easy answer is what can be done to prevent similar abuses going forward? And I think the mechanisms for dealing with that for the moment are not working well. In theory, the easiest remedy for presidential law breaking is impeachment, but this is one of those things where the founding fathers did not foresee how things would work, and they didn't foresee that partisanship would make it virtually impossible to successfully impeach and remove a law-breaking president. There are other things Congress can do, such as trying to withhold funding and the like, but they create problems of their own. So I do have some ideas I'm trying to work on and what can be done, but I admit it is a very difficult problem, and we need more people, perhaps even more of your listeners, thinking about how to address it, because while I think the law in this area is generally good, the enforcement is extremely problematic and frankly kind of weak.
All right, where can people find you?
Sure. So I write regularly for the Volokh Conspiracy blog and the Reason website, VOLOKH. Many of my writings and talks, including probably in the near future this one, can be found on the Cato Institute website, CATO. If you just run my name through the Cato website, you find my page where you find all my stuff. And then I have my own website at the George Mason University site, where I also have links to many, many of my writings. Just Google my name and you can find that website as well. And of course, you can buy my books at fine Amazon outlets near you.
Professor Somin, thank you so much for taking the time today to talk to us, and thank you for all you do in fighting for the Constitution and liberty. You, sir, are very much appreciated.
Thank you for having me. Great questions.
And audience, thank you so much, and we will see you tomorrow at our regular time, 12 p.m. Eastern. Have a good day.